So we talked about provisional broker. We talked about our broker. Let's talk about our broker in charge. Your broker in charge has a lot of responsibility in addition to making sure that the agents or the brokers are doing what they're supposed to be doing. And not breaking the law and filling out contracts right and all of those other things, right? So let's talk about what their job is and how to get there. I want to be a broker in charge. I'm going to have to complete my 75 hours, pass my state exam, do the post-licensing courses, right? I can't be a provisional broker. Not allowed to be a provisional broker with to be a broker in charge. You have to be a full-time, active, right, with 2 years of full-time actual brokerage experience. All right. So 2 years of actual brokerage experience, active, okay, has to be active. All right. Can't be a provisional. And I have to complete that 12-hour broker in charge course within 120 days of declaring myself as BIC eligible, broker in charge eligible. Okay. So I have to let the Real Estate Commission know that. Okay. So a couple of things that are important here. A few things that are important, actually. First one of the broker in charge's responsibilities is ensuring their brokers complete their mandatory continuing education on time. So let's take a moment and talk about continuing education. Every year, we as licensees, brokers, have to take 8 hours of continuing education. Now, 2 4-hour courses. One's a general update course, and one is a general elective of any assorted amount. One's a mandatory state required course. The other one is an elective. But the thing about continuing education is it's not, as a provisional broker, when you just get your license, you do not have to do continuing education in your first year, in your first licensing year, because it's assumed that you're going to be doing your what? Your post-licensing, right? So let's say that I get my license in February this year, right? Let's say March 1st. I don't have to do, I have to renew it in June. I have to renew it at the end of June, and we'll get to the dates in a little while. So I have to renew it in June, but I don't have to do a continuing education for 2023. Now, before I renew it in 2024, next year, I'm going to have to do 8 hours of continuing education. Okay. Matter of fact, tomorrow morning, just an FYI, I got to do my general brokerage, my Gen Up class tomorrow morning. So we all have to do it. 8 hours, a 4-hour general updates course, which is the laws, and then a 4-hour elective. So, but a provisional broker doesn't have to do it in their first year. So when, another tricky question that comes up all the time. When the question comes up that says that it is mandatory for everybody to do 8 hours of continuing education every year, it's not necessarily true. Provisional brokers don't have to do it the first year, do they? So be very aware of that, all right? Everybody else has to. Once your first year is over, you must every year, that's correct. But that first year, you don't have to. June 31st is the last, or June 30th is the last day you can renew your license and remain active, regardless of when you renewed your license. So yes, that'll be put everybody on the same time frame. We want to do the CE. Second bullet down there on the bottom in red. Also must make sure their firm's transactional records are available upon request for review by commission auditors. And how long do we have to keep all records? We have to keep everything for 3 years from the end of the transaction. 3 years. So if they are disputing, let's say I have a buyer and seller who are disputing earnest money, and it takes 3 months for the judge to decide how that money is going to be dispersed. The 3 years doesn't start until we disperse the money. So it's 3 years from the absolute end of that transaction. Trust money, let's talk about it a little bit. Anybody buy a house, you're going to put what? Earnest money down, right? And you're going to, we're going to give it to the broker. Broker's going to put it in his trust account. Could be earnest money, it could be tenant security deposits, could be rents, prepaid rents, right? Or rents that are going to the owner, they go into a separate trust account, right? HOA dues and assessments, each HOA has their own trust account, okay? So this is money that belongs to other people, all right? That we are a custodian of. We're holding it for some future date, for something to happen in the future. We're just holding the money. So that's what trust is, trust money. We are the custodian of it. We could give it to the attorneys and let them hold it in their trust account, but a lot of companies are still keeping it in their own trust account, and that's their prerogative to do so, okay? So these trust accounts, they have to be separate. By separate, we mean they only contain monies belonging to others. I can't put my money in there with my trust account. That would be commingling, and that would be illegal. All right, I can't do that. So other people's money only. And I'm going to have to keep a ledger, and I'm going to keep, I have to keep detailed notes and letters and things of that nature, withdrawals, all right? It's got to be a custodial account, which means the broker, only the broker or broker's designated employees have access to that account. So if you have an administrator or some type of accountant who's looking over that, making sure all of that stuff is done, just the two of you, the broker's still responsible. The broker is still responsible. So you can't just bail your responsibility to somebody else. You're going to be responsible. And that money has to be available on demand. So if my buyer decides they want their money back and they're not going to buy anything, I have to be able to get it back to them virtually once their check clears. Okay, I need to be able to get it back. So it has to be available on demand, right? So funds may be withdrawn at any time prior notice. Primary features of these trust accounts, rules, okay? They have to be federally insured. So it has to be federally insured. Now, they have to also lawfully be doing business in North Carolina, okay? Doing business in North Carolina. So it doesn't mean that they have to be located in North Carolina. It's just that they have a license to do business in North Carolina. And they have to agree to make the account records available for inspection without notice by the Real Estate Commission. The Real Estate Commission can do a spot audit, okay? They can do a spot audit at any time. They can go into the trust account and take a look. Make sure you're accounting for every dime, okay? So the bank may be located outside of North Carolina as long as they are lawfully doing business in North Carolina. Now, no credit unions, no credit union. Because the credit unions are not federally insured. They are usually state insured, or they have some sort of insurance, but it's not federally insured, okay? So you may not have a trust account in a credit union, not allowed. So how many trust accounts do I need? If I don't accept any money from anybody, I don't need a trust account. But if I'm going to take other people's money, such as earnest money for purchases, I need at least one. Now, I don't have to have a separate trust account for every person. I can have one trust account, okay? And I can put it all in there as long as I have good accounting practices. If I don't take any money, I don't need any, all right? So here it says a requirement, all earnest money deposits, tenant security deposits, rents, and other trust funds may be deposited into one trust account. You can have more than one. It's okay. You can have as many as you want, but you can do it with one, okay? So you can have a general sales trust account and a rental trust account. Sometimes they have tenants trust accounts and then owners trust accounts, right? Whatever that is. so that we can make sure that the owners get their money. Okay. Now, here's the big kicker, though. If you manage HOAs, homeowners associations, a lot of money coming in and going out. Each homeowner association must have a separate trust account. Okay. So if you manage 10 HOAs, you have to have 10 trust accounts for your HOAs. Each one has a separate trust account. All right. Somebody just bought a house. My buyer just bought a house. They handed me a check for $10,000. They said, here, Sam, hold this for earnest money. All right, well, I got to get that money into a trust account, right? Now, I can hold a check. So it says here, earnest money deposits, and we have 3 banking days to get them into the checking account or into the trust account. 3 banking days. Mm-hmm. If we get a check, I have 3 banking days from acceptance of the offer. So let's say my buyer is negotiating a contract, writes out the check for $10,000. He hands it to me. I'm holding it. We didn't get a contract yet. We don't have any agreement. We're going back and forth. Okay. Once we get acceptance and we get signatures on a contract, I have 3 days from that point to get it into the trust account. Okay. 3 days from that point to get it into the trust account. Okay. If it is cash, it's immediate. Okay. No longer than 3 days. If it's a check, I got until they can get into some sort of agreement on the contract. Now, the reason for that, first of all, cash gets lost and there's no accounting for cash. So you got to take that money and you got to get it into the trust account. Now, there are a lot of companies that will not take cash. Okay. Your company could be different and that's okay. But, you know, there's a lot of companies who won't take cash. When we get a check, we'll hold that check until they get an agreement. Because this way, what happens if the agreement falls apart? You just hand them his check back, right? Or her check back. And then they can tear it up. So not a big deal. But if we decided that we were going to deposit that check and they were arguing and that thing fell apart, well, then we got to go through the bookkeeping of waiting for that check to clear and then get the book work, you know, do the journal entries, everything else, get them a check, all that stuff. And that could take a little bit of time, right? If I'm waiting for a $10,000 check to clear, is my trust account just going to say, yeah, no worries, give them the money back? I doubt it. Okay, I doubt it. And that was a problem, not recently, I haven't heard any recent cases, but that used to be a pretty big fraud thing. People would write checks and you deposit it into your trust account, and then they would get into a contract, and then they'd break away from the contract, and then they'd want their money back, and then you would have to write them a check. Turns out you write them a good check, their check goes bad, right? That's why we hold checks. We don't want, and now couldn't possibly until that check clears and hits the bank, they won't get any money back. But all of that being said, with that is that we'll give them the check back now. Here's your check. Okay, if it goes bad. But cash you got to be careful with, because cash just disappears, right? People like cash. So do the bad guys. So we have 3 banking days, no later than that. Now, as a provisional broker, you get no days. You immediately have to give all of your trust money to your broker in charge. You do not get to hold checks. You do not get to hold cash. You don't get anything. You get to collect the money and give it immediately to your broker in charge, okay? There are no exceptions, all right? You cannot hold, as a provisional broker, you cannot hold trust money. More on trust accounts. Trust accounts are extremely important, okay? On your checks and on your deposit slips, it has to have the word trust account or escrow account written on all of these bank statements, checks, and deposit slips. ABC Realty Trust Account, ABC Realty Escrow Account, has to be on all of them, okay? Now, it also says there in the second bullet point, we can never be commingled with non-trust account funds. I'm allowed to keep $100 of the company money, ABC Realty money, in there so that it covers any check charges or anything that has to be paid out of the account. They can take it out of the account. It keeps the account open up to the $100. If it ever goes over $100, I got to withdraw that money. I can only keep $100 of my own in there, all right? And I can replenish it up to that $100. That's all. I can't put commissions in there. I can't put, money for bills or anything else like that. That is other people's money. I am not allowed to put that in there. It is for trust money only. Okay. So how many trust accounts must the BIC or firm have per office? They don't have to have any. Okay. They're not required to have a trust account unless they take money. All right. Unless they're holding trust monies, earnest money, security deposits, rents, in which case they need a minimum of one trust account. One. Now, I know that in your lifetime as a real estate broker, you will never, ever get a buyer and seller who disagrees on anything, because they just, once they get into a contract, they're constantly in agreement for everything, right? They will argue about the sky being blue. They will argue about anything. Therefore, what happens when the deal gets bad and the buyer says, I'm not buying this house, and the seller says, I'm not selling this house, and you're holding $10,000 of the buyer's money, and the seller says, they walked away from the deal, I want the earnest money, you give me that $10,000. And the buyer says, oh, no, they're not doing the right thing, they have bad inspection, I am walking away and I get my money back. What do I do? What do I do? This is called disputed trust funds, okay? Now, in order for us to give it back to anybody, we need a signed release from both parties. So we need to be able to tell the seller, here, you sign this, and the buyer, you sign this, and then we'll give it to the appropriate party, okay? Whatever the two agree to. If they don't, we are going to hold this. We're going to hold the money. We're not going to give it to anybody. All right. And we're going to file an interpleader with the court to the magistrate. Okay. We're going to go to the court and say, hey, we have this dispute. What do you want us to do with the money? And the magistrate can say, all right, well, let me look at it if he's got time. And he'll tell us how to disperse the money. But if he doesn't, he can also say to us, yeah, we definitely need a written release if we're going to do it, okay? But he can also say to us, the judge can also say, turn it over to the clerk of the court. And when he tells me to do that, I'm going to turn it over to the clerk of the court, and the clerk of the court is going to hold it until the judge decides, okay? Now, normally when you go to these, when you go to an interpleader, if you lose, first of all, you have to show up. If you don't show up, it's going to be a summary judgment against you. If you do show up and you lose your case, you're going to pay court costs and any other costs in addition to losing the money. So there are some penalties for not being a reasonable person. There are some penalties. Okay, but I cannot just arbitrarily take that out of our trust fund. In order for me to get that out of my trust account, I need a written release from the buyer, signed by the buyer and the seller, in order for me to give that money back, with instructions on to how to disperse these funds. Buyer gets it all, seller gets it all. We split it 50-50. Whatever that is, they have to sign off and agree. Otherwise, I'm turning it over to the judge. It's the only way I can get it out of my trust account. That's the only way. All right. Now, in the case of disputed trust funds where a judge orders the funds dispersed, and I mentioned this earlier, the broker must retain records of the transaction for 3 years from the date of disbursement, the end of the transaction, right? So it may be 2 months from now. We know this deal fell apart. My 3 years might not start until March. Can a broker in charge firm have an interest-bearing trust account? Yes, they can. Yes, they can. Okay. It'll be disclosed in the listing. It'll be disclosed in the sales contract that the broker in charge will maintain all of the, will maintain all of the interest that the trust account brings. And because of the costs and the manpower and everything else, it doesn't amount to much, right? It's a little bit, but we just have to disclose that that's what will happen. Okay, they are allowed to have an interest-bearing trust account. We talked about this earlier. Can a firm have a trust account with a credit union? No. No, it's not FDIC insured. All right. So it says they have to be held in a bank and savings or savings and loan, federally insured and lawfully doing business in North Carolina. All right. They don't have to be. The bank doesn't physically First Third Bank doesn't have any branches, I don't think, in North Carolina, but maybe they do. I mean, every bank is in Charlotte, but they're not all over the place. They can still do business here as long as they're lawfully insured. They're here lawfully. They have a business license to do so. Limited non-resident commercial broker, and I touched on this earlier. First point: he resides outside of North Carolina, and they have an active broker's license in their qualifying state. Maybe it's Virginia, maybe it's South Carolina, maybe it's Georgia. All of those, Tennessee, all of those touch North Carolina, believe it or not. All right. So you could have a commercial license somewhere else. But I want to come in, I want to sell commercial real estate only, not residential, commercial only in North Carolina. All right. So I have to enter into a declaration of affiliation and a brokerage cooperation agreement with a resident broker, resident North Carolina broker, not a provisional broker. All right. Not on provisional broker status. It has to be a full broker. All right. Declaration of affiliation and a brokerage cooperation agreement. Sign those off. It says that they're going to be responsible, and I'm working through that company, and I can conduct commercial real estate brokerage in North Carolina. Not only does each individual need a license, but your business entity and your firm needs a license. ABC Realty needs a license to do business. XYZ Realty needs a license to do business. If you want your team to be an LLC, your LLC inside your team has to have a license. All right, you got to go to the Secretary of State and get your license from the Real Estate Commission. Okay, so business entities, corporations, partnerships, LLCs. All right, if you're a sole proprietor, you don't need to do this. But if you are part of a group that's a corporation or an LLC, all right, you have to get a separate firm license. Separate firm license. Okay. So you're going to go to, you're going to get your LLC from your Secretary of State, pay the fees, list the people, all right, who's going to be the recording secretary, who's going to be the signature authority, all right, and then you are going to get a firm license from the Real Estate Commission. Even if you're working for XYZ Real Estate and you want to be the Sam Hassel Company or the Sam Hassel Group, you have to, the Sam Hassel Group working as an LLC would have to get a firm license. I can start my own team, that's not a big deal. But if I have it registered at the state as Sam Hassel LLC, then I need a license for my firm, even if I'm working for XYZ. So last sentence there, you don't need a BIC license for a firm unless you plan to advertise or hire people. Kind of talked about that, right? The importance of having one so that we can do the things that need to be done. Going to be important. June is a big deal. We have until June 10th to do our 8 hours of continuing education, our 2 4-hour courses. Okay. We have until June 10th. We can't do it. We can do it before then. We can't do it after then. So June 10th. If we want to stay active, we got to get it done by June 10th. If we don't do it by June 10th, we will be inactive if we renew on June 30th. Let's say June 30th comes and I didn't take my continuing ed, and there's no continuing ed classes between June 11th and June 30th. There are none. They're not allowed to be given. They're not authorized or anything else by any school, even online. There are none. So there is a 20-day blackout period. Now, if you have not taken your CE by the 10th, well, what you want to do is on the 30th, pay, or in between that time, pay the renewal fee anyway. You will only be inactive. You'll only be inactive, all right? But what you don't want to do is not pay that fee, because if you don't pay that fee, regardless of whether you took that CE or not, you will have an expired license. Your license will be expired. So you would rather be inactive than expired. If you're inactive, you do your CE when it starts over again. Once that's all completed, you do a $90 application fee to the state and you get your license back activated. Yeah, expired after 2 years means you're back here. Yes, exactly right. If you go expired for 2 years or longer, you start all over again. You get to see me again. Do this from day one. Why you would want to do that, I have no idea. But yeah, that's exactly right. Right? So yeah, if you expire for 2 years or longer, you automatically start as if nothing ever happened. You start back on, day one. This is your textbook. Yeah, and that's not cool. All right, it's hard to do it a second time. It's hard enough to do it the first time. To go back and do it again is even more difficult. Another 75 hours and then your 90 hours if it didn't happen. All right, so key points here. The 10th is the last day you can do continuing ed. No continuing education between the 10th and the 30th. If you did not take your continuing education by the 10th and you still pay your fee, you will be inactive, can't do any real estate, but as soon as you do that, you'll be activated again. If you don't take if you don't pay this, regardless of if you took your CE or not, if you don't pay by the 30th, you are expired. And then the clock starts. And when we get into the notes pages, we'll see how that works. Make sure on the 30th you have already paid. All right, regardless of if you've taken those CE classes or not. If you want to keep your license, you want to pay it. And then you can just make up the CE deficiencies down the road. Because you go expired and you're out for any length of time, the clock's ticking on you going backwards. And that means that you could end up being back here in 2 years. So we have an active license. We've done our continuing education before June 10th. We pay on before June 30th. I believe everything gets paid, by the way, through that website, through the Real Estate Commission website. So you don't have too far to go. They accept all your payments. They do everything there. They're really good. The window opens on May 15th. So you have May, 2 weeks in May, and then the month of June to pay it. So you got about 6 or 7 weeks to pay it. Make sure you do your education. I'm not kidding when I'm saying tomorrow. Tomorrow I'm doing my my Gen Up. We call it a general update, Gen Up. So I'm doing 4 hours tomorrow. And then in February, I got to take a weekend course. I just want to get it done because what'll happen is come May, I'll forget. I'll get busy or won't have time. I'll be teaching 2 classes and won't have time. So I got to do it. You'll have the same issues. Provisional brokers have to pay the first year. Yes. If you get your provisional broker in March, on June 30th, you need to pay the $45. Start all over again. New license for new year. Okay, looking at the slide here, an active license. You have to have an active license to receive compensation for commission. All right, in order to deal and do any real estate, you have to have an active license. Same thing with referral fees. The bullet point down on the bottom says may not collect referral fees with an inactive license if the referral was made after the license became inactive. Let's say on June 15th, I sold a house. I got a contract on a house. After June 30th, now I'm inactive. Because I earned my money while I was still active, I can get paid. But let's say on July 1st, that my house that I had listed goes under contract. I am inactive because I didn't do my CE. Can I get paid? I cannot get paid. I have an inactive license. So you have to be active. And it's when you get, when you earned your money is when, whether you were active or not. Okay. Cannot get paid on an inactive license. You're not allowed. Even referral money, unless you made the referral before you went inactive. Current license, but cannot engage in any brokerage or marketing activities. Can't do anything. Put away your business cards, put away your brokerage book, put away everything. You can't do anything until you do your continuing ed. If you paid the $45 annual fee and you failed to complete the continuing education, you're inactive until you do it. Second bullet point there with a PT on it. No marketing of any kind, including handing out business cards with an inactive license. We all think we can still hand out business cards and solicit. You can't do that. You can't even talk about it. You can't say, I'm a real estate agent. I'm a real estate broker. I'm inactive right now. Technically, it's a break-in in law. An expired license is a little different. This means you have no license. You're not even inactive. You have no license. So you failed to pay the renewal fee on or before June 30th. Every one of our licenses expires at midnight on June 30th. Regardless of if you took the continuing education or not, if you don't pay the fee, you are expired. And big red down on the bottom here. If the license remains expired for more than 2 years, the person will be required to retake the 75-hour class and pass the licensing exam to reinstate. That doesn't sound like party time, but it is what it is. All licenses expire at midnight, June 30th, and we will bring it to you here. Real Estate Commission Rule A 503. Okay, you don't have to remember that, but just know that they do that. All real estate licenses expires at midnight on June 30th each year. PBs as well, provisional brokers as well, which means that you got to renew your license. Payments received no later than June 30th, and everything through the website, NCREC.gov. All right, you pay everything, get everything through the website. Pay the renewal fee, keeps your license on the current status. All right, did your continuing education, paid it before the 30th, you're good. If you want to keep inactive, even if you don't do the CE, you still should keep inactive. You still have to pay the fee. Still have to pay the $45. All right. I know that's a little redundant, but people don't realize that. If you pay the money, you're inactive until you do the CE. If you don't pay the money, you're expired. All right. Licensee who fail to pay the renewal fee will have their license placed on expired status. And you can pay the real estate commission. Does the CE hours requirement continue to count up based on years? Yes. And when we get to the notes, there is a pretty healthy session on if you're out this many months, then you need to do these courses plus the others. Same thing with inactive. Yeah, it adds up. It's cumulative. By the time you're out, even if you're inactive over a period of time, you could end up doing a couple of those post-license courses and the year's current CE. So the longer you wait to stay inactive, if you want to come back, they're going to put some time in. We'll do in the notes that I showed you earlier. The whole thing is broken out for you. We'll go through it. We'll go through it. When you're filling out your application, all right, they're going to ask you for any criminal activity, background checks, things of that nature. Please don't lie. Please don't lie. If they find out that you presented fraudulent information or forgot to tell them something, they'll hold it against you. Okay? They'll hold it against you. They'll hold it against your trustworthiness. And they kind of, until you throw yourself on the mercy of the court, you have to do some groveling. They may or may not give you a license. If you go in front, the very last thing they're going to do is they're going to check your background check. And they're going to see if you have the required requisite character. And if you have a character flaw, they're not going to give you a license. Okay? So that's something that just please be Better to tell them and then explain it to them than not tell them and have them find it. All right. So don't falsify documentation or failing to disclose prior criminal convictions, even a DWI. Now, keyword here, convictions. We're not talking about arrests. We're not talking about accusations. We're not talking about anything like that. We are talking about convictions. If you have been convicted of any of those things, you must report it. Also, if you have been convicted of anything in another licensing agency, like I have a license in South Carolina. If something happens with my South Carolina license that they've revoked it or suspended it, I have to report that to North Carolina. The Real Estate Commission, their purpose is to protect the public in dealings with real estate. That's their purpose. You are not the public anymore once you get your license. So their job is to protect the public from folks like us. Not that any of us would try to do anything impossible, but we believe it or not. I know you're going to find this hard to believe, but there are some unscrupulous individuals in the weeds. Some of us would not be so kind-hearted. Not many of us. We're all pretty good people, and we're all trying to earn an honest living. But sometimes you shortcut the system. And then when the Real Estate Commission gets a hold of you, I promise you they're going to tear a chunk. Right? They're going to tear a chunk. They're not going to let you slide. Right? Because their job, their entire purpose is to protect the public, making sure we're not dealing with fraudulent individuals. It is composed of 9 members. 9 members, all right? 3 have to be brokers and 2 have to be at large. In other words, no broker's license. So the balance can be made up anyway. So you have 3 brokers and 2 that are at large with no license. That leaves 5 others in the middle, or that leaves 4 others in the middle, and they can be either licensed or not. Okay, either way. And they're appointed, 7 of those are appointed by the government, by the governor. 1 is appointed by the Speaker of the House, and 1 is appointed by the President Pro Tem of the Senate. Okay, so we have 9 members, 3-year staggered terms. That's what they serve for, 3-year staggered terms. 3 of them have to be brokers. 2 of them have to be non-brokers, at law, what we call at-large members. All right, the rest can be any mix of those. 7 of those 9 are appointed by the governor. Right, 1 by the Speaker of the House, and 1 by the President Pro Tem of the Senate. All right, so a little bit of all of that. They can license real estate brokers. They can improve real estate schools and instructors, educate and inform the public and brokers, regulate real estate business activities, make laws by passing laws, right? Investigate the suspected real estate brokerage activities of unlicensed entities. If you don't have a license, they can investigate. Now, if they investigate and find out you don't have a license, they can get a judge to do a cease and desist, right? But they are not going to settle, they're not qualified or classified to settle a dispute between 2 brokers arguing over commission. They will not do that, okay? So it says does not settle commission disputes between brokers or issue discipline from these disputes. That's a National Association of Realtors thing. Now, for example, please don't ever stop or delay a closing because you have 2 brokers fighting over a commission split. I promise you that is the fastest way that you can end up losing your license. Because they're there to what? Protect the public. 2 brokers squabbling over a commission split is not the public. Who did you hurt? You hurt the buyer and the seller, who are the public. So they do not take kindly to that. So make sure that you have the attorney put that money in escrow and then argue it out with your brokers in charge after the fact. But make sure the closing goes through the way it's supposed to. Disciplinary action. This is important here. Disciplinary authority of the Real Estate Commission. They can censure you. All right. Censure is like a reprimand, right? A hand slap. Don't do that again. We're really mad at you, right? But don't do that. All right. And it's an official formal statement. Now, they can also reprimand you and give you a written reprimand, an official scolding by formal statement. Remember when they used to put stuff in your permanent record at school? How many of you were threatened by, oh, that's going to go in your permanent record? I still have, my permanent record's got to be this thick. I have never seen it. I don't know. Worried about that stuff when I was young. So that's going to, reprimand's going in your permanent record. The difference between a censure and a reprimand is levels. A censure is a, stop it, we don't like what you did, but, you know, it's not bad enough to give you a formal scolding. A reprimand is a formal scolding. It's just a little more intense than different levels. Now, the Real Estate Commission can also suspend your license for a period of time, whatever they decide is fit, and then they can revoke your license. They can take it away from you. Like anything else, they can take your license away. So yeah, I like the way Shanta put it. It's timeout versus punishment. Really, that's what it is. All right. So they can suspend your license for a period of time, and they can also make you take educational benefits or educational classes to get it back. And the last one is if it's bad enough, they can revoke it. They can take it away from you. Now, the red in the bottom is important. Real Estate Commission cannot fine you. Notice that there's no fines here. So they can't fine you, all right? They can't mandate reimbursements to consumers for losses. However, there's always a however, right? You notice that everything that we've been talking about and everything else is in the license law. When we say law, who arbitrates the law? We get in front of a judge, right? So the Real Estate Commission can put your person in front of a judge. Can that judge fine you? Judge can fine you. Can that judge put you in jail? If it's bad enough, judge can put you in jail, right? So everything that's written into the general statute is written into law. So again, yes, they can't fine you, but they can take you somewhere that they can fine you.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.